I came into criminal defence law because of a case that I experienced when I was younger, before I went into uni. It had a personal impact on me. It was a case that was run as a self-defence argument. It was a gentleman who was protecting his family members. Had a jury found him guilty, he would have served years in prison. The case was run impeccably well by the instructing solicitors and the barrister that was brief, and thankfully he was acquitted and was able to continue to live his life and support his young family. It's for that reason that I decided to become a criminal defence lawyer. Attention to detail is where I thrive. I enjoy receiving a brief of evidence and looking at the details to establish where the evidence will support our defence, but also what information or documents I need to obtain from my client, and more often than not from external sources, in order to support the case that we want to run for a successful outcome for our clients. I recently acted for a young man who was charged with the rape of a close female friend of his. He was 23 years of age at the time of his trial. He and the complainant had known each other for many years. They had mutual friends, and my client even considered himself a good friend of the complainant's boyfriend. It was a case where my instructions were that there had been a sexual encounter between them, but that it was consensual. And whilst he and she had been out on the town drinking for some time, just prior to the alleged offending, the complainant was not so intoxicated that she could not consent. The prosecution case relied heavily on her statement, versions of the event that she had given to various witnesses, as well as some text messages and phone call records that she had provided to police. My instructions and the case was run on the basis that it was regret on the part of the complainant that she had lied to and cheated on her boyfriend, and regret also on the part of my client that he had, in that sexual encounter, within minutes ruined the friendship with her, and also in turn ruined his relationship with her boyfriend. When I analysed the brief of evidence, in looking at the details that she provided to various witnesses in relation to what happened on the night, how the sexual encounter happened, how much she had had to drink, but also what she had told her boyfriend about what she was going to do that night. And the fact that she pre-planned the encounter in meeting up with and going out with my client that evening, but also pre-planned staying at his accommodation and lying to her boyfriend about those two things, I formed the view quite quickly that the complaint lacked the ring of truth. I started to analyse the inconsistencies. I obtained further records myself. I spoke in detail with my client about certain messages that he had sent her immediately following the sexual encounter and what he meant by those. And I obtained evidence through statements about his otherwise good character. Through obtaining that material and picking apart the brief of evidence in the way that I did, we were able to successfully navigate a positive outcome for him. He was found not guilty, and as a result can continue to work and study in the medical profession for the rest of his life with a clean record. I feel that it was the right outcome. I feel that my view about it lacking the ring of truth came to be true, and that we, as a team of defence lawyers, were the voice for this young man who had never been in trouble with the legal system before, had no idea how to navigate the system, or how to put forward his position in order to secure his verdict at the end. I feel great joy and pride in the work that we do, and the fact that we can offer this service and be there for people who need a voice to represent them.